Hey, it's Bill Stewart with Bill Stewart Homes at Remax Moves. We're going to go through the sales offer contract, what to look for when you receive an offer, and some of the contingencies and things like that that could be within an offer that I think are important to review. I'm not going to go through the full document, but just more kind of the I guess the high level parts that when I'm looking at a contract, what I need to know and what I need to make sure that I'm having my client understand if I'm representing them on the sell side, or things that I look for in terms of when I'm making an offer for a buyer client, like ways to be able to make sure that they're protected throughout. So this is the standard state form. This is typically what it's going to look like if you're buying or selling real estate here. If you're buying new construction, they have their own contracts, so they're a little bit different. This is like specifically if we're buying like an existing property. In the contract itself, in number one, it's going to state the parties. So the buyer, the seller, what's their names, who are they? In C here, it'll be the closing attorney. Who is the buyer selected as a closing attorney? I tell sellers, like typically buyers will say who they want it to close with, but that the idea is that the seller, if they don't want to work with that attorney, they're more than welcome to hire their own separate attorney, and then at that point, like the two attorneys would coordinate together to close the property. Down here, you're right underneath here where it says like buyer and seller, are they a South Carolina licensee? Are they a real estate agent? Is the buyer or seller in this transaction a real estate agent? That needs to be disclosed. And then here in the buyer seller section here, are they a client? Are they a customer? And have they received the South Carolina disclosure of brokerage relationships? This is an important document for all parties to understand. Where do they sit in the relationship? Are they being represented? How they're being represented, and then at that point, the just kind of what is the duties of that agent in all of these things, either at a client or customer level. If you have any further questions on that, just give me a shout. But in essence, most of my interactions that I'm dealing with are at a client level. I'm a fiduciary for my clients. So at that point, like I'm representing them, and their interests are ultimately top of mind. But there are times where I'll work where if it's a for sale by owner, or that at that point, or a buyer that's not represented with an agent and coming to purchase a listing, that if they don't have an agent, then at that point, like I would retain the client relationship with my initial client who is either buying or selling, and then the other party would then be a customer. Because of the fact that I'm not going to, I guess, breach my relationship with my initial client. And so this just kind of outlines what the responsibilities are. Number two is going to be your purchase price. How much are they offering? This is by far the most, this is what people, when I'm talking and I'm settling offers, this is what they're mostly focused on, to see what is the actual purchase price offer. And then below it is how are they purchasing it? Is it going to be finance? Is it going to be cash, a mix of cash and finance, or is there some other way of what it is? If it's a cash offer, are the proof of funds attached, or are they not attached? And if they're not attached, then at that point, when will the seller expect to get that proof? And then below that is the contract itself contingent on the sale of another property? So if the buyer is trying to sell their house, do they need to sell their house in order to be able to buy this one? If it is contingent, then there's another form that needs to be attached, which gives all the information about the property, who they're working with, and giving you full transparency into the property in which they're selling. If they're under contract, there's another form. And so at that point, it's kind of giving when the due diligence period ends, when the closing date is, all of those things which are important. In three, it's basically outlining the property. This is really to make sure that we're making an offer on the property that we're actually intending to buy. There's no discrepancies or issues. We're not buying the neighbor's house. We're buying the house that we want. And this is also this is information that the closing attorney will use as well to understand the real property that they're going to be doing title search and all of that stuff for. In number 4, it's the conveyance, the possession. When are you going to close? Where are you? Like how far away are you going to go? Is it 2 weeks? Is it 30 days, 45 days, 60 days? So on top of purchase price, how long will it take that buyer to actually close on the property? And then below in here is where that's going to be the name in which the title will then where the attorney is going to put the title. Whose name is it going to be in? Those things. Your buyers and sellers will initial each page. They've read all of this. Number 5 is earnest money. How much? Earnest money is a good faith down payment. How much is it? Is it coming with the? Hold on. Is it coming with the offer, or is it going to be brought at some other point in time? And then that we need to stipulate what date it's going to be there and how is it going to be paid, either check, cash, wire, anything along those lines. In my opinion, a good earnest money deposit somewhere between 1% and 2%. That means that they're pretty serious. The lower it is, it kind of all depends, I guess, on like what the motivations are on either party. But the bigger this number is, it's good. Now, this is not money that the seller gets to keep if for whatever reason the sale doesn't go through, but it is a deposit that goes in. The buyer can't just call the closing attorney and say, I want my money back. Once it's deposited and it's with the escrow agent, who the escrow agent would be stipulated here as well. Typically, it's going to be most of the time your closing attorney. But in order for a buyer to get that money back, there's actually a document that you would have to send to the attorney, which is instructions on how that earnest money is dispersed if for whatever reason the deal fell through. But it's a down payment on the property, but it's not necessarily a non-refundable deposit to the seller. So just making sure that when you're looking at it, but the higher that number is, the more motivated, in my opinion, they seem to be. In here, there's another section where it talks about, if for whatever reason there's an issue with the earnest money, and it required that there was a need for an attorney to step in, that there would be a certain amount that would be held back from that escrow, from that earnest money deposit, in order to pay for those fees. I see a variety of different charges here. Typically, it's somewhere between $200 and $400. That's only if, for whatever reason, there's a dispute that requires the need for somebody to do further paperwork or work. Number 6 is your transaction costs. Okay, it's in 1 and 2. It's talking about what the buyer closing costs are traditionally, what the seller transaction costs are as well. And then number 3 is, in addition to any of these costs, that where it would be that either it's going to be a seller or buyer transaction cost. If nothing's checked in this box here, then these are traditionally seller expenses, but you want to make sure that this box is either not checked or checked, where it's either that you understand that who's paying these things. If you're a buyer, or if you're a seller, the idea that just being aware of the additional cost outside of attorney fees and commissions, where you are, in terms of financially. Number 4 is like transaction costs that are above and beyond. So sometimes I see this in a variety of different ways. We did a video about compensation agreement. If there's a compensation in place, and then the commissions would not be put in here. But if you have a seller that is not going to sign a compensation agreement as part of the offer, this is where you would see potentially what they're asking for in terms of closing costs that can be used towards paying that buyer agent, or it could be, if there's a compensation agreement in place, this could be closing costs in addition to that. Sometimes what I see in here is that agents will they'll have a compensation agreement in place, and then they're also writing the commissions in here. It's not that they're trying to double dip or anything. Sometimes they may not necessarily know. And so it's important to review this, knowing kind of and knowing where you stand with those things to make sure that it's not, we're not confusing the process here. But it's important to know what they're asking for from a closing cost. If those closing costs are being used for buyer agency compensation, then below here is that buyer and seller would initial that they understand and agree that closing costs amount that can be used towards buyer agency agreement. Both buyer and seller have to agree on this, and so at that point, like you would put up to a certain number. And I think this is an interesting choice of words, up to, because of the fact that like it's even throughout the process, things may change. So it's that you're agreeing at this moment to those things, but that it's negotiable all the way through the entire transaction. However, if you've got a number here, say you're offering $10,000 in buyer agency compensation, for this number cannot, the number in 4 cannot be the same number here. It's got to be offset slightly. So you can't, 100% of those proceeds can't go towards buyer agency compensation. So sometimes you'll see that they're asking for $10,000, $10,001. And then at that point down here, you'll see the 10,000. It's the way that with the new changes, that's how it's written. That's what they have told us that we can or cannot do. And so that's where you'll see sometimes an offset in that. And then you would initial below as either buyer or seller. When you're looking at special assessments, this is something that you want to look at is how, if you have special assessments or if there's known special assessments, and say if it's a one-time charge, typically sellers will pay that, leading up to close. But if you have something where you have an ongoing assessment, say they're doing street repair or they're doing some sort of like clubhouse work or community or amenity repairs that could potentially be on a month, like they're having you pay over a period of time, it's that they understand their responsibility up to closing, or that the buyer could check here that the seller is responsible for like any of the assessment costs through the next 12 months. And so understanding kind of what this is going to look like, calendar year, but the idea that you understanding that there could be continued cost or an additional amount of money that's going into the settlement statement to take care of these things. So knowing whether they checked option 1 or 2, a lot of times they see option 1, but there are times where the seller could be on the hook for those things afterwards. 7, if you know that it's financing, which was checked above, then at that point there's a finance contingency. This is saying that the contract is contingent or is not contingent upon financing, what kind of financing it's going to be. Then this here is really important. How much are they financing? So what's the percentage of that financing? Are they financing 80%, putting 20% down? Are they financing 100%? This is important to look at because depending on how high that percentage is, that basically it's a percentage of the purchase price or appraised value, which means that, if the appraisal value is lower than the actual selling value, then there's what's considered an appraisal gap. So if this number is like 100%, the question would come down to, if there was an appraisal gap, would that buyer have cash capital to be able to offset? So it's a good question to ask. Then at that point, the idea of like when they need to start their finance like application, they could have a pre-approval, but at that point, like they need to go ahead and move into actually like applying for the loan to get their pre-qualification or their actual approval. Then at that point, they should deliver like all of these things, like what date do they need to deliver all of the information, and that they need to be able to show the seller that they are actually pre-approved, and what date is that going to be. If they change their lender, they need to notify the seller as well. Say they come out and they've got one lender, then they shop around, find somebody better, that they need to make sure that seller understands that they are making a lender swap, and then at that point, like therefore that you can evaluate, because if they change a lender 2 weeks before close, that could potentially slide the closing date because of the fact that it won't be enough time to actually get everything through underwriting. So this is the lender name, who they're using as their lender, and then what type of financing that they're using. And so sometimes the actual loan type could be challenging depending on a couple of different factors. So it's just being aware of those things. If it's a government loan, FHA, VA, then there could be not just due diligence in terms of like the buyer's inspection, but then there's an actual like lender inspection and appraisal. So it can add some further inspections to the property. So it's just understanding what that's going to look like. Due diligence. What due diligence is? This is your due diligence end period. How long are they asking for the due diligence period? And what due diligence is the opportunity for a buyer to go through inspections and vet the home to make sure that it's that they're happy with the overall condition. And so in here, you want to look at your due diligence period and make sure that it's not something where it's like a 30-day due diligence period where at any point they could walk away. The idea, you want that to be a more compact timeline. I would say sometimes I see between 10 and 14 days seems to be the average, giving them enough time to go out and do the inspections, evaluate what they've got, and then their findings that they are able to then at that point send it to the seller to make any repair requests that come along, and giving the seller enough time to be able to respond where it is. Now, in here is also going to be your termination fee. So buyers have the opportunity in due diligence to walk away. If they're not happy with something, they find that the roof is not in the condition that they're comfortable with assuming, then at that point they can walk away. However, this is where the termination fee is important, because at that point, like they would have to seriously consider, is it worth walking away because of the fact that they would have a financial obligation to the seller because of the fact that you took it off the market and that it delayed, days on market, those kinds of things for them to actually sell the house to another buyer. So this is pretty important. I would say you want this to be as high as possible because you want it to be where the buyer is not only committed to putting down the earnest money, but also the fact that they're not just coming through willy-nilly running inspections and then turning around and just that there's no skin in the game for them. So that number, it would all depend on pricing of the house and things like that as to where it is. But what's interesting about the due diligence period though is once that buyer goes through, does their inspections, and they send you the repair request, that at that point that ends your due diligence period. They don't once you've they've presented you with repairs, and then the seller agrees to whatever those repairs are. It doesn't matter if you put a due diligence period of 30 days and then 2 weeks you're handing in your repair request, that you kind of get one shot at this as a buyer. So at that point, but once you've negotiated your repairs, the buyer can't just come back afterwards and say, I want to re-inspect this or think it through. You get one time in there. So regardless of what it says that due diligence period is, once you get your repair request and you've negotiated all of those things, then at that point, due diligence is now done. Buyer is completed that, seller has completed that. And so at that point, now you move from a contingent to potentially a pending offer, depending on what's going on. Then buyer seller would then also initial the bottom of this form. Inspection rights, where is it? Idea that the seller has to maintain things like your utilities, power, water, so that they can actually do an inspection of the working components of the house. If for whatever reason the house is empty and there's no power, then in the buyer's like, well, I want to turn on the utilities so that we can evaluate. You'd want to check here that that says that the seller is granting the buyer the opportunity to connect those utilities in order to conduct those inspections. So just knowing kind of knowing that what that is, typically that's going to be pretty well stated through the transaction, but it's one of those like buyer just can't come in and start making changes to a property without the seller's permission. Appraisal is the contract itself. Number 10, is it contingent upon an appraisal? Typically, if it's financing, it's going to be contingent on an appraisal unless for whatever reason the bank sees that it can be waived, or they would check yes or no. This is just the bank's like a bank evaluation to make sure that if they're going to offer a loan, that the property itself is valued at a number that the bank is comfortable with issuing the loan. Number 11, the wood infestation report. This is one that I see a lot where I see that this is a separate inspection. So outside of due diligence, this is a wood infestation report. CL 100 is what it is commonly referred to. The other is that this is looking at any sort of wood eating bacteria, algae, those kinds of things, as well as termites. So that this is a completely different contingency. So you can get your repair request and repair report, and then you can get the wood infestation report, which could be then at that point like additional. There could be additional things that the seller might have to do in order to get this cleared. If it's contingent, typically if it's financing, it's going to require that a CL 100 is being done. I see this, where the wood infestation report's pretty standard. Especially here in South Carolina. So it's important here to know, whether if it's contingent or not contingent, and then who's paying for it. Is the buyer paying for it, or is the seller paying for it? Who's ordering it? Those kinds of things. Sometimes, most of the time, this is a buyer expense as part of their inspections, but there's times where I see that it's pushed back to the seller. So knowing where you got. And then the other is then at that point, like it can't be done any farther out than 30 days before close, but then that the buyer has to present that CO 100 within a certain time frame. Typically, it's going to be within like 10 days of close or something like that. So that would be the date that you want to take a look at. What's the survey? If there's a survey that's required, who's going to pay for it? Those kinds of things. Typically, it's going to be a buyer expense. But that could also be something that's negotiated as part of the terms. Then when you're looking at, is there a home warranty that's being offered? If so, who is it being paid for? Who's paying for it? And when would it be? When would it be where it is? When would it be delivered to the buyer? I see this in a variety of different things. It's asked for. Sometimes sellers will offer it just as an upfront thing, or sometimes it's paid for by like agents themselves to protect their clients, and then you would sign down here. That you're going to go through. This is kind of boilerplate in terms of most of this. Number 16 is another one. Where did the buyer receive the seller's disclosure statement, which is the condition report of the property? That they received it, they understand it, that they would have had to sign that document, and that typically is something that's going to come along with this offer. If there's no seller's disclosure, are the buyer and seller comfortable that they will not complete one? That's something that's negotiated up in the front. So just understanding that that's there. If it's checked yes and there's no seller's disclosure, then you need to get one put together. And then we move down. Number 19, talking about what you can do with that earnest money. Can that earnest money be put into a interest-bearing account that it's either that they may or may not. So I most of the time this is no. In my opinion, I don't want earnest money to go into anything that might have any sort of risk. And ultimately that the whoever is holding the escrow agent really shouldn't be profiting, in my opinion, off of deposit money that's not theirs. But I see sometimes that it's checked mark yes or no, depending on what side of the table I'm sitting on. If I'm representing the seller, buyer, the buyer agrees to it, that's up to them. But I would probably not advise that way. Buyer and seller then would initial down here. we move into kind of what, kind of understanding a little bit more about the broker's compensation, how that's all done. And then in here, number 28, there is going to be, this is an option, and I'm going to show you something else back up on the top. There's two places where they could be asking for things, or that there's other supplemental documentation or contingencies that they would have. It's important to look down here. Things like where they're going to ask for, they potentially could be asking that there's a contingency on like the fact that they want these appliances or want this or that. There's another spot up here at the very top of the contract where the conveyance and possession here, it would be here. Where is it? Oh, sorry, right here. That the parties agree that no personal property will move within the property. What that is like if you're asking, if this is blank, it's no big deal, but this is where they would typically put things like a fridge or any furniture or any things that are not necessarily attached to the house. They would have to stipulate that their offer is also inclusive of those things. But as you move down here at the bottom, this is also another spot where I've seen from time to time where they're also adding in things like fridges or washer and dryer, things that they've seen while they're on site, as well as announcing that there's other documents that may be attached to this contract. And then the expiration of the offer. When is, like, I'm making an offer today, I'm going to give the seller a certain timeline to evaluate and respond. And so at that point, it expires at what time, either AM or PM, and then on the date that they want to get an answer. So sometimes I'll see a variety of things. Sometimes it could be like a matter of hours that they want to get back if the buyer really just wants the seller to make a decision. Or it could be 2-3 days, depending on where it is. But ultimately, they have time to evaluate. Buyer is now waiting for the seller to go, and that they're stipulating, we want to know within a certain time frame whether or not you agree or not agree. And then if this party has been done, been written and somebody's writing it on their behalf, then they would also need to that the power of attorney or those kinds of things that they would need to either have that attached or that it would be delivered by a certain date, allowing somebody to work as a third party on behalf of, say, the buyer, where it is. And then buyer and seller would sign this notice, address, and email, fax. This is like if there was an issue as far as like if the buyer terminated the contract, this is now how they notify and where they need to deliver the actual termination fee. And then the same thing here for the seller. You'd want to have an email address, a phone number, and an address of who it is that you want to be that intermediary, or it could be a brokerage office, things like that. A lot of times I see this not put in, or it's just an email. It's important that there's an address there because if you can't necessarily deliver a check specifically to an email address, so it's important to have that. And then down below are the information about the agents that are working, their license, their office code, who's their broker, what's the email address, phone number, how would I get in contact with this person? And so at that point, we would want to have both the agents' information there. And then buyer and seller would initial, and that is the contract. Now, one thing that I would say too, when you're looking at a contract, is that due diligence and earnest money a lot of times get commingled. So I see contracts a lot of times where I will get that the earnest money, the date of the earnest money deposit aligns with the end of the due diligence period. And most of the time it's explained that it's just easier for the buyer, that they only have to write one check as opposed to figuring out two different checks, and that it's written on a convenience. They're not trying to do anything shady, but the idea is that that they're kind of misunderstanding, I think, sometimes what those two mechanisms. There is a reason why it's stated it's two different sections in the contract, because it's actually two different mechanisms within the contract itself. Earnest money, in my opinion, needs to be deposited within a few days of the contract actually being accepted by the seller. That good faith payment is being handled by the escrow agent. and that due diligence and the termination fee is a very separate thing, because it's not necessarily that it's going to come out of earnest money or that one check, or these, it's, you need to have the good faith down payment, in my opinion, to have a good contract. And then if due diligence were to go, then that money's already deposited with the escrow agent. It could be where in the earnest money instruction back to the attorney, if they were to walk away from the sale, that it would be then at that point stipulated that the termination fee could be taken from that earnest money deposit. But if not, then it's an actual check that seller has to deliver, and has to deliver in a timely manner, because once due diligence ends, if there's been no, if the buyer doesn't send in a terminate, like doesn't rescind the offer because of whatever they found and pay the termination fee, or they don't give you an actual repair request or answer within that time, once that due diligence period expires, then at that point the buyer is on the line to actually sell that, to buy that house. That means that they are agreeing with the seller that they are committed and full and in the glide path to closing. So it's one of those, like, if you're a buyer and you think that you have to notify people if you've decided not to. You can't just avoid it because of the fact that you have a signed contract with that seller that you are now moving in. And after that due diligence period, it's pretty difficult to get out of without that seller agreeing to release the buyer from the contract overall. So I know, hopefully it's helpful. I mean, there's a lot more to it. If you have any questions about the contract, please feel free. We'll take a look at anything that you get. If you want us to review it, we can do that. But in general, it's just making sure that you understand it's not just about the purchase price. There's more to the contract itself, and really understanding all of that will help you to evaluate, one offer against another in terms of what that means from a net perspective as a seller, or as a buyer, understanding what your costs are going to look like, on top of all of the, outside of just your financing closing costs, but what are you agreeing to, and understanding that. So hope this is helpful. And like I said, if you have any questions, our contact information is in the description, and we hope to talk to you soon.